Hi Purnima, how are you?
I'm good. Thank you.
Am I audible, comfortable?
Yes, you're audible.
Well, I just put the video on because the bandwidth consumed is slightly higher, so I'll just put it on for a while and then we'll refer to the screen.
Sure. I'll go on mute till then.
Yeah. Hi guys, I'm Khurana. I'm from Khurana and Khurana IT Attorneys. We'll be taking the session today. Tosif, I can hear you. Cecily Hyacintha, am I audible?
Yes, sir. This is Jacinta.
Yes.
Yes, sir. You're audible.
This is Tosif, and you are audible. Hi, good morning, all.
Hi. Excellent. So it is 10:59. We'll just wait for a couple of more minutes to see if anybody else is going to join in. Else, we start off. It's an informal pedagogy. You know, I don't usually try and follow a lot of theoretical exercises and formal mechanisms. So let's stay in touch. You can just keep asking questions. I'll pause in the middle, and you can ask me whatever questions that you have, any pointers that you want to deliberate and sort of discuss out with the team. So just unmute yourself and ask me till which time I think all of us can be muted so that there is more bandwidth control and there is more disruption. I also have Tapan. If you can probably see Tapan, can you give a very quick background? I'll in fact give a very quick background myself. I'm Tarun Khurana. I come from a high technology background, electronics, mechanical, software side of practice, but have been doing patents for the last 18 odd years. So I've been drafting applications in all the domains. I don't draft as much now, but I sort of work with a team that does very active drafting. And therefore wanted to take this session. A lot of us are working from home, almost everybody for that matter. So I thought it's a good time for us to get together, do a quick small course on patent drafting, try and spread whatever experience that we guys have gained and learned from everybody else as well. So this is me, and I'm one of the founding partners for Khurana and Khurana. We are about 180, 200 people practice across 10 offices in India. Tapan, am I audible to you?
Actually, I'm noticing his audio, I think is not enabled or something.
So Bhumika or Arindam, can one of you please call him up and ask him to
We'll check it in the background. Yeah.
All right, so I'm now going to share a presentation, and please feel free to stop me wherever. So don't wait till a pause or something. Just start questioning whatever that you want to. Okay. So this is the first presentation that we'll refer to today. Just 1 second. So although the session today will primarily focus on patent drafting, because that's the 6 hours that we have together with each other. But the main intent for today will be on claim drafting in particular. Tomorrow, we will do specification portions, abstract, brief description, what to write, how to draft, everything as part of the detailed description. But today, 90% of our focus will be only on claims. And then what we will do is by the end of tomorrow, I will send a sample patent invention disclosure to everybody. And I think on Monday, we will deliberate and discuss the claims and the specification of everybody. And try and, I would expect if everybody could sort of spare some time on Sunday, maybe not the whole specification, whatever they can write in the time that they have. And so that on Monday, when we all sit together, we probably have more aspects to take care of. Can everybody see my screen?
Yeah, I'm not able to see this. Yeah, it's appearing.
Yeah. So this is the presentation that I'll be referring to. And please feel free, as I said, please don't wait for a pause because that will take the process longer. So just so that I can see everybody and anybody who's raising questions or commenting or anything, I will keep the slide mode like this only. I'll not make it the full screen, otherwise I'll not be able to see other things. So very quickly, next 15-20 minutes on what patent applications are and how they're sort of structured in a general sense. This slide essentially indicates the prerequisites of a patent application, we all understand that patents, very quickly to rewind, are for 20 years. They are territorial in nature, given only in the country in which you apply for them. So if you apply for a patent in India, you are only protected in India. If you apply it in the US, you are only protected in the US, and everywhere else it is in public domain, and anybody can use and commercialize it in their respective country. India and almost all of the countries in the world, I have a filing system of first to file, which means that whosoever files an application first gets the patent granted to him, and gets the rights of the patent. So it does not really matter whether you've done more research or you've basically sort of been higher up in the overall data that you essentially have from the processes that you have run, or your research is in more advanced stage. It purely depends, and what matters at the end of the day is who files the patent application first. So it's first to file, and therefore sometimes this documentation of who was doing the research, at what stage, what kind of data did you have access to, can help you establish your ownership onto the patent. And especially in the pharmaceutical sector, where the sensitivity is too high. Just 1 second. The new people joining in, so just sort of admitting. Arindam, can you admit them as well? Okay. So maintaining a diary or a record of this nature is very important, where by virtue of the details of, say, for example, the date and the title and the table of content, we are able to very comprehensively establish that this is the research that I was doing, and this is the data that I had, so that tomorrow, if hypothetically somebody even steals, or there is a theft of intellectual property for some reason, then you can go to the court, or you can even oppose the patent application through a pre-grant opposition, and in the during opposition proceedings, that the patent was wrongfully obtained, it was stolen from my side, and here is the evidence for that. So a lab notebook or a laboratory notebook would really help you maintain your data properly, become a good evidence. You could, and I will share the slide later over the email as well, but it is not only about what you do, but also taking signatures of your guides, creating as much more evidence as possible, so that good practices and proper practices can be incorporated, so that tomorrow, if, for example, an employee of yours leaves and joins another company, you are able to establish that he was working on the same invention while he was here in the company, and therefore this what he's working on in the new company is illegitimate and constitutes a theft of intellectual property. So these are again some prerequisites. You could have the date and the signature and the experimental data signatures and so on and so forth. And even the appraisals have now become, for large pharma, healthcare companies, their appraisals also have a big portion associated with the documentation. So how accurate your documentation is becomes very critical sometimes for these reasons. And this is a snapshot of how your notebooks can actually be maintained. Going beyond it, we talked about patents. It's an exclusive right given by the government for 20 years, but it is given in exchange of a disclosure. And the patents always reward disclosure than secrecy. So it's very important that we disclose as much as possible to substantiate the fact that whatever we have written in the patent application can actually be implemented or enabled. So there is a very clear requirement in the Patents Act which states that your applications have to be enabled, and which means that your specification has to be comprehensive enough so that whenever somebody reads that, just 1 second. So that whenever somebody reads your application, he should be able to make it. Somebody having ordinary skill in the art should be able to make that particular subject matter from an implementation standpoint. And therefore, disclosures are very important. Explanations are extremely important. Patents are territorial right, as we talked about. There are 3 tests for patentability: novelty, non-obviousness, and utility. Because a few people here don't have a significant background on patents, and therefore I'm just sort of going very quickly through the highlights of what patents are. So 3 tests for patentability are novelty, in non-obviousness, and utility. Novelty is basically destroyed when you are able to find a single document that discloses each and every aspect of your independent claim or of the subject matter that you're trying to claim protection of. Non-obviousness is essentially from an inventive step standpoint. If the examiner is able to cite 2 or 3 documents and say that you've combined the learnings or teachings or suggestions of these 2 or 3 documents, and therefore your invention is absolutely obvious to a person having ordinary skill in the art, then your invention is basically refused from a patentability standpoint on the ground of non-obviousness. Utility means that it has to have industrial application and should show consistent results. So the same results should be obtained every time we do the same implementation of the invention.
So, hi, I have a question here, if I may ask. This is with respect to the utility standpoint. So sometimes in FERs, we are getting objections like due to the presence of no in vivo data, for example, in pharmaceutical applications, not all the time we submit in vivo data. So sometimes we get objections like there are no examples to show that your invention is working in the in vivo sense, no experimental data kind of a thing. So how does one overcome such kind of enablement issues in the specification? Like most of the tests are usually done using cell lines and all that stuff. So could you please elaborate on that aspect?
So, the kind of data would also depend on what the invention is all about. In most cases, the clinical data that you essentially require is good enough for most controllers. I mean, if they need certain specific data, you can also tell them that, at the time the application was filed, this was the kind of data that we had, and that data should, you can always argue that that data should be good enough for you to demonstrate efficacy of the invention, or sort of demonstrate or substantiate what was being claimed in the subject matter of the invention. But if there is any more data that is required, and if that's practically possible, you could seek more time. I mean, we've always ask controllers, or even between the time we reply to the examination report and before the hearing, we've had numerous clients where they've generated the data at that point in time, and that data is correlated with the data that was generated earlier, and that sort of helps you overcome the requirement for the support of the data. Tapan, are you there? Just wanted to make sure that he's there as well. Arindam, were you able to speak to Tapan? I can't see his audio here. Yeah, so Tapan will try and contribute more because from a technology standpoint, Tapan will try and contribute more from a pharmaceutical standpoint. He can configure his audio, and then he'll probably be able to answer this question. But I'll note this down as well.
Okay, thank you so much.
Very quickly, the process we are all aware of it. We file the patent application, it gets published by default after 18 months. We have to file the examination request within 48 months, file the reply to the examination report within 6 months of time, and then the application is in order for grant within 12 months, but it usually takes much longer after the response to the examination report has been essentially filed. It could take 12, 15, 16 months also. Provisional versus complete, I think the understanding is very clear on this aspect as well. A very good way to understand whether to file a provisional or complete is that if you are at a stage of invention or specification drafting or invention development where the next 12 months can help you add more meat to the application, you can add more data to the application, you can add more provisions to the application, you can add more embodiments to the application, then filing a provisional definitely makes much more sense. I'm just admitting one more colleague. Yeah. So, however, if you think that you are where you are and the next 12 months are not going to add any further value, if you think that all the data that you have intact, even if you had 12 more months, you will not be able to add any more clinical data in vivo, in vitro, whatever data that you essentially would have, or that your invention cannot be broadened out any further, it is what it is, then you file a complete application. And that's probably a good test for you to decide whether you want to go for a provisional or not. I think the rest, everything that I've written down in the slide is fairly clear of the advantages of a provisional application and what the advantages of a complete specification are. This is where the patent drafting comes in the whole life cycle. There is a technical problem that you're attempting to solve, and then you find a possible solution. At that stage, you decide whether you're too early, you are still in the process of research, but you want to protect your idea, and therefore you file a patent application at that stage. And then there is prosecution of application, grant and publication. There is, and then you could commercialize it, enforce it, and enforcement would also have issues of validity, would have issues of freedom to operate, and so on and so forth, which is not the subject matter of the course today. So these are some important aspects which we all have to be aware of in a patent application while drafting, and we will go into the details of it in time to come. One, you are not allowed to continue to paint the picture. So once you have written a patent application, a complete specification, you cannot add anything new to the specification after having filed a complete application. Barring the data that we were talking about, the clinical data, which is sometimes acceptable to the controllers as regards the data which can substantiate the working or the efficacy of the invention, that is acceptable and sort of taken care of during the prosecution. But you cannot add any new embodiment, feature, any implementation, any aspect of the invention after you've frozen the entire application. So therefore, it becomes very important for you to make sure that your specifications are healthy, and then they are comprehensive in terms of the elaboration that you've done. Even if you've elaborated but you've not enabled some aspects of your invention, if you've not explained them in sufficient details, that would become a lost opportunity, and then you are facing a very large section 10(4) problem on enablement. You're also not allowed to add forgotten details, which means that once you've missed out on some embodiments, as I said, you cannot add them. You cannot add any close-ups. You cannot give further clarity to the invention. You're stuck with what you have in the patent application, and you cannot get protection for what is not properly described, because examiner in all likelihood will issue a 10(4) objection and say that your invention specification is not clear enough or is not fully enabled, and hence under that ground alone, he could very well refuse the application from being granted. Before we come to what independent claims are and what dependent claims are, it is important also for us to understand what are claims. The claims, in very brief, are legal statements, one sentence at a time, which give you a very clear idea of what the invention is going to protect, what the scope of the invention is going to be. And I'm going to use these terms regularly in the next 6 hours. What is the scope? What is the heart of the invention? What is the pith and marrow of the invention? All of these are largely overlapping terms, which would try to indicate that, okay, there are 10 things that you've talked about in your patent application, but the main inventive step, the main reason why this patent should be granted are obviously not all the 10. It is those 3 or 4 that are working together that enable the improvement or that enable the solution to the technical problem that you are trying to solve. And that is very important for any patent drafting professional to understand. At what level do you claim? What should be your first claim? Because if you claim too much in terms of too many elements, A, B, C, D, E, F, and your independent claim, then you've made that claim very, very narrow. And if you've claimed very broadly where you've only talked about elements A and B, then you've kept it too broad, because then tomorrow if the examiner is able to demonstrate that A plus B was already known in the prior art, then in that case, it will become very difficult for you to substantiate that independent claim apart from obviously amending it with limitations of the dependent claim. And therefore, it is very, very important for us to understand where we are in the whole specification. Now, are we I mean, what is the core essence of the invention, and therefore we have to structure our claims appropriately, use the right terminology that is consistent throughout the specification, and write always the claims in a manner such that anybody who will eventually end up using has to use the elements of the independent claim. If there is even a single element in the independent claim that some third party can avoid using in their product and still make the same product or largely make the same product functionally similar to your invention, then all your efforts have really gone down the drain. And therefore, independent claim drafting becomes extremely important. I'm sure all of you will have read what is written in the in the slide, and therefore I'm not repeating it per se. Again, you cannot broaden the claims once granted. Even after the application is being filed out, there are very clear provisions in the Patent Act that you cannot go beyond the claim. So once you've claimed elements A, B, C in your independent claim, you can only go narrower from there. You can only add more limitations to that particular claim, but you cannot really broaden the scope of the claims beyond what you already. So your independent claim therefore becomes a very critical claim, because examiners in the patent office would not allow you to add to broaden the scope of the invention in any manner post having filed a complete application. Forget about after the grant, but even after having filed an application, they will only allow you to either amend your claims by virtue of clarity, disclaimer, and explanation, and all of those would only involve amendment of the claim to add new limitations, but you cannot really remove any limitation that is already existing in an independent claim. You cannot broaden the disclosure and the claims beyond what is already included at the time of filing of the application, as I said, and therefore you don't get any second chance to amend your claims, except maybe adding limitations or maybe for explaining certain aspects for better clarity and explanation. And therefore, you're fully responsible for a clear disclosure that is fully supported and enabled by the specification. I think these points I've already talked about. It's important to understand the heart of the invention and then proceed forward from there. These are the typical sections of a patent application. I said we focus only on the claims section as regards to today is concerned, and all the others will sort of flow in. I also wanted to explain to you while drafting, at least how we approach, or I personally approach when drafting applications. And sometimes I've seen that people take 3 days, 5 days, 10 days to draft a patent application, which to me is usually not required, unless it's a very complicated invention and would require you to write specifications far. Just 1 second. Yeah. So unless you sort of, unless you have specifications which are far beyond, say, 50 pages, 60 pages, and you really require that level of time to understand the invention and then write it. Otherwise, most applications with good 25, 30 pages, 40 pages of specification can always be written down in 15, 16 hours, which is basically 2 working days for that matter. I think all of us understand most of these sections. Title is a very, very brief section. I'll just go to that one first. We'll explain what the invention is all about. Has to be kept as broad again, because the narrower the title becomes, the narrower the construction of the whole specification becomes. The examiner then also gets a lot of keywords to search on as regards the prior art search is concerned. And therefore, if there were 2 titles like multi-state selective catalytic cracking process and system for high yield middle distillate products versus say only a multi-state selective catalytic cracking and a process thereof, for example, something of that nature, this is a far bigger, broader title which will not very explicitly give the examiner what to search on. He will have to go through the specification and develop his own understanding to undertake the keyword strings and the searches that would require to be done for assessment of the prior arts. But if we write a very narrow title, first of all, the invention looks to be a very, very narrow easy to design around patent application, and also gives examiner a lot of leeway in terms of keywords to formulate key strings from the inventive step standpoint. And post the title, we write the background, which is usually 2 to 3 paragraphs. What I'm talking about is something that I usually follow. Everybody has their own practice. Some people like writing long background sections, elaborate sections, but I would usually only give a very highlight idea that the invention, that existing arts talk about. There are, for example, the first para will be a very high level paragraph of what the current state of the art is. There are hydrocarbons that are having lower catalytic cracking, for example, and therefore, there is a lot of requirement of solutions. And then we talk about what are the existing solutions in the market in the second paragraph. And then existing solutions aim at doing 1, 2, and 3, and 4. And then towards the end of the same paragraph, we try and identify disadvantages to the existing solution. So once we've identified what the existing solutions are, we identify what are the problems with those existing solutions. And then the third paragraph is, therefore, there is a need in the art for a solution that can overcome the above mentioned problems and can move forward accordingly. So background section, therefore, to me, does not require prior arts to be mentioned. You don't need to mention, because that's the job of the examiner to do a search. So if you look at patent applications of a lot of large software mechanical entities like Yahoo or Google or Amazon or even Daimler or many other companies, including pharma companies for that matter, they don't want to reveal too much of information that is already in the prior art, and specifically the prior arts that are the closest in the patent applications background section, so as to let the ball be in the examiner's court to do the necessary search. In fact, a lot of them don't even do a patentability search, because in the US, once you do a patentability search and you have certain results, you are under the obligation to share such results with the US Patent Office. And therefore, a lot of companies don't even get a search done, and they just move ahead and draft the patent application and file for it. Description section will essentially start with a brief description of the drawing. So you have figure 1 explains this, figure 2, figure 3, figure 4, which is what we'll talk about tomorrow, and then the detailed description of the invention. And then you, in between, while writing the detailed description, it's also important to keep writing statements or paragraphs which are broad, overall broad in the whole horizon, which sort of give a broader perspective or positioning to the entire invention, like boilerplate languages. This can also be there, this can also be there. So we try and not only write the core embodiments, but we write more generic statements to say that these are only exemplary embodiments, and then the whole scope of the invention is far broader and beyond what has already been mentioned. Anybody has any questions at this pace? Am I going too fast? Am I audible properly? Anybody has any questions from that perspective? Tosef, can you hear me appropriately?
Yes, I can hear you properly.
All right. So just pause me wherever you need some clarity. All right, so this is the description, and then we come to the claims. We've already talked about that the claims form the most important and fate deciding part. Whatever is not claimed, so if you've talked about 10 different aspects in your patent application, but you've not claimed them, everything is disclaimed. So you really have to introspect on whatever are you writing in the specification. Are you making sure that you're claiming everything? And if you're not claiming it, you have to make sure that it is in the public domain, and you are deliberately and by intent not claiming it, from the claim standpoint, because if you do not, then you've lost all your rights, and tomorrow you cannot really add new matter to your claims or to the specification as well. Just 1 second. Important terms have to be defined and used consistently. We cannot really use a shaft at one place and then refer to the same element by a longitudinal member or by any other third term for that matter. So once you have defined a term for a particular meaning, you have to use that consistently throughout. The claims have to be as broad as the prior art allows. You should include several types of claims depending on the invention. You could have a device claim, which is also an apparatus claim, a method, a product, or a composition claim. And then you could also use antecedent basis. You will have to use antecedent basis very appropriately and critically to ensure that there is very clear linkage between all the elements of the claim in totality. Elements of the claims should be supported fully by the description. They should be explained, enabled, and we should avoid negative limitations. Negative limitations are statements like that this parameter value or the temperature value will not exceed or does not exceed 70 degrees, for example. That's a negative way of stating it. You could also say that it is under 70, but if you say it will not exceed 70 is a negative limitation. So my composition comprises A, B, and C and does not include D. And that is a negative limitation. But sometimes the inventions are such that the inventive step is that negative limitation, which means that the core heart of the invention is in the ability of the product not to include certain elements which were there in the prior art before. So if the product, like any spray, for example, had certain ingredients A, B, C, and D historically, and you've been able to make an equally efficient or highly, same composition with high efficacy without the use of D, but and D was supposed to be an integral component, then you can always have a negative limitation to indicate that the inventive step itself is the non-use or non-incorporation of certain elements. So two types of claims we have talked about. There is an independent claim and there is a dependent claim. Independent claims form the heart of the invention. They are the ones that give the broadest possible protection, and they are the ones that are interpreted from an infringement standpoint as well. They are the ones that will be looked upon first. They are the ones that will be interpreted the first to understand their scope and construction. No dependent claim can ever get infringed without the infringement of the corresponding independent claim on which it corresponds. So here, in an example, you can see an antioxidant composition comprising in a weight ratio of 1:3, at least one amine comprising of so and so, and at least one mannose base obtained from the reaction of so and so, and aldehyde, and said composition being effective in a predetermined amount of stabilizing gasoline, and so on and so forth. So this is an independent claim that is a composition claim that talks about two ingredients. One is an amine and the other one is a mannose base in a ratio of 1:3. And then and then they've talked about the use of the composition, that it is effective in stabilizing gasoline and gasoline components. Before we move forward, dependent claims, we all know what they are, but this is how a dependent claim would look like for the same invention. That a method, ideally it should be, so I've basically reiterated the same independent claim as before. And then we've talked about dependent claim, where they say that the method of claim 2, wherein the effective amount is 5 to 50 mg. Now, before we move any further, there are certain fundamental principles for determination of infringement of a patent. There are two main rules. One rule is an old rule called the all elements rule, which says that a product infringes on a patent only if all the elements of the independent claim are present in the product, which means that if an independent claim has elements A, B, C, any product that has A, B, C will essentially infringe on that respective patent. So if it has A, B, C, D, it will infringe. If it has A, B, C, E, it will infringe. And if it has A, B, and C, and instead of C, if it has D, then it will not infringe, because it does not have all the elements of the corresponding independent claim of the patent. There are doctrine of equivalences. I am not going into those at this point in time because it will take more time. We can deliberate it toward the end of the session if required. Because if C and D in such a case are equivalents of each other, use of D instead of C will also constitute infringement. But that would need to be seen from an assessment standpoint of, is D a very well-known substitute for C, or is it something that would probably is not an obvious replacement for C, for example. So there are subjective parameters, but the simple test is that if I have a patent and a process, I look at the independent claim of the patent, look at the number of elements, and if everything is written, everything of the independent claim is there in my product, then I'm infringing, otherwise I'm not infringing. That's a very clear objective test. Now, sometimes, in fact, this was the test, say about 6, 7, 8, 9, 10 years back, but now the courts have evolved in India, and the test has gradually moved towards the pith and marrow assessment, which basically says that the test would not be done solely based on all elements into consideration, but also look at what the pith and marrow of the invention is. What is the core heart of your invention? So if your patent has a claim A, B, C, D, but the main reason why the patent was granted, which can be assessed from the prosecution history, is the use of B and C together, which were never done earlier. A was also there, B was also there, C was also there, D was also there, but in no single composition was B and C used together. And that use of B and C together led to the improvement in my invention. Just one second, somebody is on chat. Right, so if B and C together, use of B and C together led to the improvement of my invention, then the pith and marrow of the heart of the invention becomes B plus C. And anybody using B plus C together, irrespective of whether they're using A and D, will also be under the gamut of infringement as regards the patent is concerned. So that's something that is very important for us to remember from a pith and marrow or from an essentiality test for infringement that is being used and relied upon by most courts at this point in time. Any questions that anybody has? Because this test of infringement is very important and necessary for us to keep in mind while we are drafting patent applications. Any observation, any question at all?
So you said the Indian courts are just considering the pith and marrow type of the consider. Does the like US and EP, they all go by this way only?
So most of the times these days, I mean, they may call it some other test for that matter. They may call it a test which may not be called the pith and marrow evaluation, but the heart of the heart matter is that all elements has gone down as regards the priority is concerned, because sometimes the claims include a lot of elements which really are, I mean, if my invention relates to a bottle that has a capacitive sensor coming from the below, and that sensor has an ability to coordinate with my mobile phone through an app and tell me the hydration parameters of the water that I've had in the last, say, week or 10 days or 15 days, and is able to determine a historical pattern on the same, that if by chance I have written that I have a cap on that bottle as part of my first independent claim, and tomorrow somebody says that, okay, I have no cap at all, it is blocked, or I basically have a hole from which anybody can drink it through a straw, but there is really no cap required at all, then merely because he wrote about the cap, but the cap never formed a part of the inventive step at all. It was just added so as to complete the disclosure of how the bottle may be captured in a cap, but still using the main reason why the patent was granted would constitute infringement in most territories at this point in time. Tapan, you said you were there. Can you contribute on the tests in the US and Europe as well?
Yeah, so basically, each this particular
I'm not able.
The pith and marrow test is basically, used in European region specifically
Tapan, we are not able to hear you.
during somewhere 1980. Yeah, am I audible?
No, Tapan, you're not audible. Do you want to do another connection with the hotspot? I think we'll wait till Tapan. We'll continue and Tapan may join in then once he has a better connection. So yeah, so globally the test is becoming is moving away from the all elements tool because that becomes very detrimental sometimes for and it gives a very clear opportunity to the defendant or the infringer to maybe exclude one element and get away from infringement, and therefore over a period of time the test has become more on the pith and marrow or the essentiality ground. Essentiality means the core essential aspect of the invention being the parameter for infringement detection. Now, under this understanding, I just wanted to understand one question from everybody, or anybody who might want to. Is it better to have a claim which is long with many elements, or is it better to have a claim which is short with as minimal number of elements as possible?
So a shorter claim with minimal elements is more recommended.
That's correct. So anybody else has a different opinion here? Anybody else says that a longer claim is better?
I think as far as we cover our the core heart of our invention, then the shorter claim is the preferable.
That's correct. That's correct. So moving on, I think that is probably the best way to move forward. There is an example that I use, and we can probably spend 5 minutes on that as well. The example goes like this, assuming you are in the 15th century at this point in time, and there was no chair to sit on. Everybody used to sit on the ground, and somebody very intelligent came up with a chair having 4 legs and a seating mechanism and a back to support the back. So there are how many elements in this product now? How many elements are there in the product? We have 4 legs and a sitting mechanism and a back to support. How many are we all on the same page that there are 6 elements?
Yes.
So assuming that, so there are 6 elements, right? 4 legs, each leg is a separate element in totality. And when you will claim it is when you will realize that there are 6 elements. If this is the product that the inventor came to you with and wrote a disclosure explaining how his chair would look like with the support and the back and everything, what according to you should be the first independent claim in such an invention? Assuming that the prior art is somebody sitting on the ground, that's it.
I
Yes.
think
Yeah, guys, why don't you contribute? Yeah.
I think hi. Chair with a seating mechanism itself, if we can cover, because the legs and everything will be the members which will support it.
Correct. So what are you suggesting? What would the claim look like? A chair, but there is nothing like a chair, right? What would the claim specifically say? A device with a sitting mechanism?
Maybe it could be a device with a seating mechanism which has supporting members probably, and this could be supporting members could be later covered in the dependent claims. Maybe.
But sooner you say supporting members, aren't you saying that there are at least 2?
Yeah, definitely.
But can't there be a single leg from the that can support?
I don't think that can be a single leg. With the invention point of view, to support.
Yeah, but there are legs, right? There are legs that are coming from the center of the chair, and then they expand.
Sure. Yeah, definitely. Yeah.
Anybody has a better suggestion? Anybody has a better claim broader than this?
We can say it like at least one supporting member.
At least one supporting member. Yeah. Okay. So a sitting but the question is, you've not talked about where the sitting element is. Is it elevated or is it on the ground?
It is elevated above the ground, because prior art is something like people were sitting on the floor. Then there must be a small sitting element which must be above a height from
Right.
the ground.
So the claim would look like a device having an elevated sitting mechanism supported by at least one leg. Am I correct?
Yes.
Anybody has a better claim than that? Mohan, are you trying to say something?
Yeah, actually, I want to say instead of mentioning the number, we can say the legs. Because if you mention the leg, then it will be the defined. If you mention the one leg or four legs, the other person can make a chair with the 6 leg or 8 legs.
No, the question is, if you say at least one leg, and tomorrow so let us assume that the claim says an elevated sitting mechanism, a device comprising an elevated sitting mechanism with at least one leg. Now, if somebody, and this patent gets granted, and tomorrow somebody makes a product which has 4 legs, the same product, having 4 legs and a sitting mechanism and a back, is that product infringing on this claim?
Maybe something is addition, but it is not an inventive.
Mohan, your point is not clear. Could you explain?
Because one leg, if you are adding 4 legs, is not very inventive.
No, correct. So, but the question is not about inventiveness, right? The question is that you wrote a claim for an elevated sitting mechanism supported by at least one leg, and you have a patent granted now.
Okay.
And tomorrow somebody makes a product after the grant of your patent, makes a product which is what the inventor's product was, which is 4 legs, sitting and a back support. Is that product infringing on this patent? Yes or no? That's the question.
Yes.
Yes, it would be.
Yes. It would be.
It will always be infringing, because the test of infringement, again, you will have to apply the simple test of all elements. As I said, the simple test is he having all the elements that you have claimed? What is your claim? You are claiming an elevated sitting mechanism. He also has an elevated sitting and at least one leg. Does he have at least one leg? Yes, he has at least one leg, because he has 4 legs. So sooner he has all the elements. It doesn't matter if he has 6 legs or 8 legs or 100 legs. The question is, he at least has one leg, and that is what your claim said. And therefore, there will always be infringement. But is there a broader claim than this? Because are there in the balcony, there are chairs that are hanging from the top, right? With a rope, for example, or from a chain. How would that claim, if somebody made a product, that product, would he infringe?
No.
No, he won't.
Correct. So then our claim did not perfectly cover every possible elevated sitting mechanism, right?
Right.
So then probably our claim should have been an elevated sitting mechanism, a device comprising an elevated sitting mechanism, and that's it. And then the dependent claim, where the device of claim 1, wherein said device is supported by at least one leg, wherein said device is made of wood, wherein said device has a back. So you write 100 dependent claims, whatever number of independent claims you want, dependent claims you want to write, you can always write them. But your independent claim has to be written after a lot of thought. We cannot write our independent claim thinking that this is the broadest possible protection, because there could always be an opportunity where somebody would try and design around your invention and try to not use at least one claimed element of your product. And therefore, claims, when writing a patent application, here is what I do, and everybody can share if they have specific opinions in that front. I always write the claims first. claims are to be written based on the description, but I read the invention disclosure, understand the invention disclosure, and then close the invention disclosure. Then I just don't refer to it, I don't rely on it at all. Once I've understood what the invention is all about, I write the whole claim set, say 10 claims, 15 claims, 20 claims, depending on the subject matter. Then the first claim becomes your abstract. In easier terms, like for example, if you're stating that a device comprising of a processor and a memory, or a composition comprising of an element A, or catalyst, or whatever, carriers and stuff like that. If there are 3 or 4 elements, then the language can be smoothened out better in English. But in essence, your independent claim becomes your abstract. The whole claim set can be copy pasted in the summary section, and you can really make a summary out of the whole claim set. But you will have to change the terms. So comprising will have to become including, will become can. All the claims have to be definite, but the specification always has to be as broad as possible. So you will have to say that the composition can include. So you try and use can, maybe, as example, in an aspect, in an exemplary embodiment, in an exemplary implementation. All of these are statements which are to be used in the specification. Specification should not include comprising, should not include said, SAID, you should use the. So basically, a more simplified English version of the first independent claim becomes the abstract. A more simplified version of the whole claim set becomes your summary. From the summary, you copy that summary below, and just in the detailed description, just above the portion where you start describing the first figure, for example. So you have a brief description of drawing section, figure A, figure B, figure C, and then you write down you copy the summary and maybe write it in a slightly different language, or just copy it before the first figure. And then you start writing the description of the figures. And while writing the description, you open up the disclosure once again, and then you add embodiments and examples of whatever the inventor has given you, so as to make the description as healthy and enabled as possible from that standpoint. Am I clear? Am I sort of making sense here? Or anybody has a difference of opinion? Very happy to hear that.
So here I have a question. Coming back to the chair example, we have an independent claim which is just talking about an elevated seating mechanism, and wherein we have not covered the embodiment or the possibility that it can be hanged as well. So my question is, if we have that perspective of that particular seating mechanism can also be in a hanging way in the description enabled, can that be put as a dependent claim at a later point of time?
So not at a later point in time, because that will then become a point of debate with the examiner, because he will obviously try and bring you in section 59 one of on the aspect of new limitations being brought in from the specification. So the Patent Act is very clear. The Patent Act is clear in one aspect, but the practice at the Patent Office states that you cannot add any new limitation to the claims if that earlier limitation wasn't already there in the claim set. So if your patent application specification talks about A, B, C, D, E, F, but your claims, independent plus dependent, have only talked about A, B, C, D, E, and F is not there in your claim set anywhere, but is there in the specification, you cannot, even after that, under section 59, bring element number F into the claim, even if it is supported by the spec. That's how the examiners practice during prosecution, and therefore sometimes disallow amendments to be done to the claims by stating that although it is supported by the spec, it is in violation of section 59 of the Patent Act, which states, which indicative of the fact that you can only amend to the extent that the limitations are already there present in the claims. Okay. And therefore, to answer that question and that example, first of all, an elevated sitting mechanism will always cover a product that is hanging from the top. because that product has a seating mechanism that is elevated. So how it is elevated from supported from bottom up or from the top is completely immaterial. So I'm immaterial in the sense that it will be within the scope of the invention, because that product will be using the limitation or the element that we have claimed in our first independent claim. And therefore, you can always write a dependent claim stating that the device as claimed in claim 1, said device have basically being supported from the rooftop through a rope or through a textile or through any kind of means to support hang it from the top, for example. But that seating mechanism is what you've got a protection on. Anybody making an elevated seating mechanism is under the scope of your patent in that case.
Okay, so if I have understood correct, so essentially we need to figure out the independent claim in such a way that it is able to cover all the possible implementations in the minimum word limit.
That's very correct. That's very correct. But at the same time, you have to be smart enough not to broaden it to an extent that it falls within the prior art. And therefore, what the prior art is, what elements are they talking about, has to be an extremely important aspect. And which is what sort of surprises me, because in India and world over, the cost of doing a prior art search or a patentability search is far lesser compared to the cost of drafting a patent application, which I think is not really is not a real proportion, because searching is a very critical aspect. Without searching, if you're drafting an application, you're basically shooting in the air, because you don't even know what the prior art is. And if you don't spend enough time and money on effort on a search, then you will never be able to, with a lot of confidence, know what is the closest possible prior art that I'm fighting against. But if you have access to that document, then you actually know that, okay, this is what was known, ABCD was known, E is what I'm adding here, F is also what I'm adding, but E will get me a pattern, and therefore I only include E in the independent claim and not include F. But if I was going too broad, and if I only wrote ABCD and never even talked about E and F in the first independent claim, then obviously the examiner is going to issue an objection in the examination report, which will then mandate or require you to amend your claims to add limitations of E or F or both.
Okay, and so in this perspective, I think maybe the European style of patent drafting, the two-claim patent drafting, wherein we have this characterized by or characterized in that, would be more helpful to just delineate our inventive step from the prior art.
Purnima, it is very true what you're saying, but there is a downside to everything that is good in life, right? So the downside to a characterized claim is this: once you've said it is characterized in that, then you cannot never go back and say that there was any inventive step or a portion of the inventive step in the portion preceding the characterized in that portion. So during litigation tomorrow, it is always good to have a claim that does not have a characterizing portion compared to a claim that has a characterizing, because at least you have an argument to make that your inventive step lies in a combination of A plus B plus C plus D. But if you have a characterized portion where you've said a device for controlling effluent coming out of, say, from a machine or whatever, and then said device comprising A and B, characterized in that, the B is integrated with C and D, then what you have done is that you've admitted that A and B are in the prior art. You've admitted it. So you will never be able to tomorrow make an argument that there was any novelty in using A or B or A plus B together, because you've admitted that both of them are it. So that's the risk, that once you use a characterizing portion, it's a long shot that you've taken, that you will never be able to use that argument of any aspect of elements preceding that portion of characterized are involving any inventive step or part thereof.
Okay, so just one more question in continuation to that, if I'm not exceeding that. I just wanted to ask, like, nowadays most of the examiners are asking, even if we have given all the particular claim limitations in a clear and concise manner, they somehow say that you need to differentiate with characterized by. So is there any way, or is there any technique or tip in which you can say that that already the claims which have been drafted are well understandable without the characterized by clause? Have you ever done this in prosecution? I know it doesn't come under drafting, But
no, I fully understand, Purnima, but because we do prosecution in and out on a daily basis, so we do make arguments of that nature. But if it is very examiner focused, if the exam, it depends on the tone and tenor and the feel factor and the kind of comfort that you have with the examiner. If you could tell him and explain to him that all the elements actually work in conjunction of each other, and therefore for us to characterize certain portions and not characterize the other portions will make it very difficult for us to enforce such a claim in the future, he may buy that argument and allow you not mandate you to put the characterizing portion. However, if he's a very adamant controller and wants as a practice that every application that he examines have to have a characterizing, then you try and convince him by including the minimal number of elements before the characterizing portion. Say only include A, characterize in that said device further comprises element number B, which is operatively coupled with A, and said A plus B when coupled with C enable you to do this. All right, so you sort of have to gauge of whether you will be able to argue, but I think it's worth arguing at least once by telling him that all these elements are not really working in silos. And because they're not working in silos, it's difficult for us to characterize some portion and not characterize the others. And,
okay, so
he may buy that argument. But if he doesn't, then you might have to. But in that case also, you can be smart enough by including minimal number of elements before
the characterized by.
Yeah.
Okay, thank you so much.
Tapan, is your connection better? Because I think your contributions would also help on the first aspect of in vivo and in vitro studies being asked by the controllers. What is important on the in vivo? And I mean, if somebody only has one type of tests, how can we counter the argument if the controller asks you for the in vivo also?
So basically, I hope that I'm audible now to everyone, and just wanted to share a few of the experiment. My experience in that regard. With regards to in vitro and in vivo, tests that need to be laid out in the detailed description. Per se, the law does not require any specific test. I believe this question might have come with regards overcoming the objections of section 3D, where one need to specifically show how it is more efficacious as compared to the previously known. I mean, when we are comparing the efficacy of a known compound or a new form of a known compound, and in that regard, it is not necessary to show the in vivo test, no law has anywhere it is prescribed that one need in vivo test for proving that it is more efficacious. Even in vitro test simply does the job. And whenever in my experience, whenever the examiner or the controller has asked for in vivo test, we can clearly say that it is not mandatory, and such kind of tests are only available post the clinical trial has begun, and accordingly there is no need of providing, and we can just draw his or her attention toward the fact that the in vitro test has clearly proved by way of empirical data and empirical evidence. We have clearly shown that in the in vitro test, the compound or the claimed compound is more efficacious as compared to the previously non-compound. So I think I have never encountered such a situation where due to a lack of in vivo data, the patent application got rejected. I mean, not in India, not anywhere else. I believe China is very stringent with regards requirement of in vivo test, but over there also we had several instances where based on such arguments we could get the patent granted.
So actually, I have a question here. Recently, I've come across such a scenario. That is why I had raised, and the objection is not only with respect to 3D aspect, but it is saying that it is not industrially applicable. So do you have any way to overcome this kind of a rejection, wherein there is no in vivo data?
Yeah, so basically, I believe that the industrial applicability, that objection might have come from China. most likely that would be the scenario. Another possible reason of raising this objection is that you have written in your claim that a sample is obtained, it must be something related to diagnostic, and you have put a line, put a expression of sample taken from a patient or a human being. The Chinese authorities, particularly the Chinese patent office, China patent office, is very particular about with regards. So basically, if the claims are drawn more towards a method of diagnosis, and where you have obtained a sample from a patient, you need to delete that claim. But in my sense, the objection must not be because of lack of in vivo data, but because the claim was directed toward a method of diagnosis. In such kind of method, Chinese patent office generally raises such an objection.
No, actually, I didn't have any 3I objection here. The objection which was only for 3D and industrial applicability, which was I was actually surprised to see such a kind of objection with respect to industrial applicability, because we are trying to show there is some kind of experimental data and like you said, empirical use of the particular elements or of the composition. So that's how I got stumped getting this industrial applicability rejection, which seems to be very weird. So that's the reason I had put in that question. So
I mean, with regards FER being issued by the Indian Patent Office, since there are many different examiners, many recently newly hired examiners, we tend to get such kind of weird objections. But you can just mention it that it is very clearly shown that the composition exhibits finds utility in this ailments or diseases, and hence it suffices the need of having adequate industrial applicability. Applicant believes to have overcome objection. I don't think that it may create any further issues.
Yeah, so I wanted to be safe rather than sorry. That's the reason I put in that weird question, because I was not able to know like how to overcome it. So that's the reason. Thank you for your patient answering. Thank you.
Tapan, one that was sort of hanging was the tests for infringement in Europe and US. So perhaps whatever discussions we've had in the past, if you could just take a couple of minutes and also highlight on how people are moving towards the pith and marrow evaluation.
Yeah, so with regards, each jurisdiction has got their own set of preferences with regards, what kind of tests they lay out, they rely on while determining infringement. So basically, Indian courts are more inclined toward the pith and marrow test that was actually, not that is, but that was being used by the UK and several other EP courts during somewhere around 1980s or so. But after that, the EP courts has started relying, has come up with another set of tests like Ketnik test, and then improved or a new version of the Ketnik test. So nowadays, generally EP courts are not relying that much on the pith and marrow test, because pith and marrow test is very rigid in terms of what is the crux of invention or what is the heart of invention, and specifically how that needs to be determined. Because it is a settled position in law that the complete specification or the patent application is directed toward a reader or a person skilled in the art. So from a standpoint of a person skilled in the art, it needs to be understood. I mean, when a person skilled in the art reads through a patent application and followed by claims of a patent application, what he perceives as a crux of the invention needs to be determined as a pith and marrow. And due to that difficulty arising while assessing who should be the person skilled in the art and what he perceives to be the crux of the invention that is laid down in the claims. So EP courts has probably now moved on toward new versions of or improved version of pith and marrow test that are commonly known as Ketnik and modified Ketnik test. And with regard to US jurisdiction, they generally use two sets of tests. One being the literal infringement, where if each of the elements of a claim if all the elements of a claim are present in the device or the alleged infringing product or a process in question, then in that case it finally decides it to be infringing. Even if one of the element is missing, then they generally rely on function by way of product by way of function test or such other test, wherein they primarily determine if how similar is the construction and what would be the end result. If there is any substantial change in the end result that may come out of that particular device or product or process, then then in such a case they determine it not to be infringing. So that would more or less comes under the doctrine of equivalent construction. And with regards to Indian jurisdiction, they still rely on the pith and marrow test.
Thank you, Tapan.
All right. Coming back to the drafting, there are several types of claims. Thanks, Tapan, for the feedback. There are several types of claims. Talk about the method and the process claim, which are largely used interchangeably. And then there are device claims and system claims and apparatus claims. And, they're also in one group of claims, and method process form the other group. Can anybody tell what kind of claims are better and broader from a scope of protection? Are method process claims better than apparatus system claims, or it's the other way around?
Actually, product by process is more broader.
But product by process claims limits the scope of the product claim to the process which is described, right? So that sort of dilutes the whole scope of the claim to the extent that the product, that some infringer, third party will infringe that particular product only if he uses the same process.
That's correct.
So, but then that is again narrow. Then you could have basically claimed just the process itself. And then a process of making, say, whatever, X composition, said process comprising the steps of, is in effect, it's the product by process claim. But a product claim in general is far better, broader, because that is independent of the process used for making it. And therefore, across industries, you will always see that a product claim or a composition claim, formulation claim, a device claim, apparatus system, all of which are in that one category of product, tangible product in context, is far better, broader than the corresponding method claim, because method, as I said, is limited to exactly the same sequence of steps that have to be followed to comply and meet it. And the product is agnostic of the process used to make it. And therefore, always remember that the system claims and the device claims should be given higher priority, because they give you high level of protection to the extent possible. To the extent possible, always try to have composition, formulation claims in your patent application and or device claims, depending on the invention field to which it pertains. Now, when somebody says that I have 100 patents, I always question that it's not about how many patents you have, but how many good patents you have, right? I mean, so this is, for example, a patent granted to Indian Oil Corporation a long time back, just taken as an example. Now, it talks about a fluidized catalytic cracking process, and then it includes multiple steps of contacting, another contacting, and transporting, separating, and then it goes to almost J. So 1, A, B, C, D, E, F, G, H, I, J, which is 10 elements. Now the 10 elements make the claim so narrow that even if this gets granted, the enforceability is so little that somebody who does not, for example, transport the portion or full of the coke absorbent into the riser without reactivation. And I mean, if he does it with reactivation, the whole claim, if implemented, where the transporting is done with reactivation, will completely take it away from infringement. Unless, again, the pith and marrow test is applied, in which case also, it's not that I am applying a pith and marrow and therefore it's not all elements rule. Even when you're applying pith and marrow, you will have to look at the prosecution history. You will have to look at what was argued by the patent or by the patent applicant to obtain the patent. But if they said that it's a combination of all the 10 and they keep reiterating it in spite of, instead of specifying 2 or 3 steps that led to the patent to be granted, then it's very difficult to comment on what the pith and marrow is. Then if it's all the 10 elements, then all the element, then it almost becomes an all elements rule based determination for infringement. And therefore, in fact, even what we write in the responses to office actions become an estoppel for us tomorrow, because if we say that our inventive step is in steps D and E together, then tomorrow that becomes a binding on us. When the matter goes to the court, we cannot say that D and E are only exemplary novel elements and even F and H are exemplary, because because you've admitted it while responding to the examination report that the key heart of the invention is the combination of D plus E. And therefore, a lot of us try to write responses to office actions or examination reports thinking that the intent is to get the patent allowed. But the question is, whatever you're writing in the response will tomorrow come back and hunt you if the matter goes to the court, because the court is then going to look at what was your argument. That is how they're going to make a determination on what the pith and marrow is. What you write in the specification, what you reiterate in the specification as what your objects are, what your advantages are, what is the key aspect, because sometimes you reiterate the key aspects 3, 4, 5 times in the specification that because of this and this, I'm able to achieve this. And if that is reiterated 5 times, it automatically will become a good contender for being construed as the pith and marrow of the invention. So I think while writing a specification, writing a claims, you may look at that exercise only as an exercise to get a patent granted, but the real story starts after that, right? Because it's very important that in the response, we only argue on very specific matters that we are very sure are the heart of the invention, and that if anybody copies should render our patent to get infringed. If you are not sure of it, then you argue on the combination of all the elements. Then you say that the manner in which we are doing A, B, C, D, then you don't give that hint that a narrow portion is what the core focus is. Let me know if there's any clarity required there. Otherwise, when these are additional examples, obviously the more ranges we include of different components, the narrower we are making the claims, the broader the ranges, the broader it is. But if there are no ranges at all, then obviously it's the broadest way possible. But again, it has to be looked upon what the prior art is, what you're trying to claim, where the novelty resides, and claim accordingly. Again, as I said, another patent, very highly narrow patent granted. And I also wanted to illustrate, so this and this are same applications. But you can see the difference that in India, the Indian Patent Office actually allowed this application with such a broad claim. This is a relatively far broader claim. And they allowed a composition patent application, composition claim in the form of composition. Here, the US Patent Office didn't even allow a composition claim, and they said, we will only allow a process claim, and that too this narrow, step still E. So that is how different the patent office has become while examining the same application, and how subject matters are prosecuted. Indian patent attorneys here would have done a good job to try and convince the examiner that we require, that there is novelty in the composition and the ranges are narrow enough. But here that argument just didn't survive. Yeah, so this confidentiality of disclosure, I think we'll come to later because it's more on the trade secret part of it. Now, because we have about an hour, I wanted to go through certain examples now of applications that we've drafted. They'll be in different domains, so stick with us for the domain specific samples and examples, but just wanted to highlight. So this is a document that we usually follow. I've cut out a few portions of it, but this document, it'll open up in a while. This document is something that we circulate internally within the firm while drafting applications. So this is a checklist that we all maintain, that this is how we have to write applications. As I had said, whenever we write the independent claim, the whole summary is put prior to the explanation of figure 1. This is all within the firm, but I'm just sort of sharing it as examples. I've edited this for the session because I didn't want to share everything, but certain examples. Now, for example, if it's a software invention, the explanation of figure 1 has to be a network architecture. Figure 2 is usually more about engines and units, and includes the detailed description. We have to explain as many embodiments as possible for description of the process flow that explains the independent claim incorporate. So if you're basically having a method claim, you almost inevitably want a flow chart in your in the specification as well. With respect to drawing, you can include boilerplate language like this. This is purely boilerplate, very standard language, but just so as to demonstrate that the method is run under a processing architecture, and these are exemplary architectures of that nature that can be made through. Similarly, we can have a computer system diagram having a VPN client and a storage device and stuff like that. I don't want to get too much into the tech part of it at this stage. Again, this is all boilerplate. So we've made many checklists like these, depending on who's drafting it and for which kind of clients are we drafting it for. So many checklists like these where this is all boilerplate, and we add that into every application that we essentially draft out. Also wanted to share this document where, for example, in the to the extent possible, we don't use words like system and method for doing certain things. We just write what the invention or what the field of the field of the invention, what it is trying to sort of give a solution to. So we just write configuration of sub interfaces to enable communication with external network devices. So we don't usually, we could have also written system and method for configuration of, but that doesn't really add any value, because you might have another different type of claim. You may have to delete your method claim. You may have to include a computer readable medium claim, and you may have two system claims. So whether you write systems and methods for, or you just write systems for, so it's just better that we've started avoiding this. Background, as I said, for us is usually around 2 to 3 paragraphs. Every attorney in the firm has his own practice. There are certain clients who want applications to be drafted certain ways, and therefore we change the checklist, but I'm just giving a generic indicator. We don't admit any prior art, and therefore, because it can become an estoppel tomorrow, and therefore we just do not include one reference, another reference, and therefore we avoid mentioning any specific prior art. We try and include, as I said, a high-level system diagram, as much hardware as possible in the patent application. You just add as much hardware in the drawings to show communication of data packets, communication through signals, bus architectures. So the more invention we explain with respect to a hardware architecture, the better it is. We don't write words like plurality in the spec. Plurality is replaced by multiple, or one or more, or one or a combination of, or at least one of. All of these are interchangeable terms that we use in the specification, but in the claims we write plurality, or we can also use, as I said, one or more, or one or any or a combination of, and stuff like that. Some clients don't want us to use the proposed method, proposed system. We can use in an aspect of the invention, in one embodiment of the invention. We don't use the word invention at all to the extent possible. We use disclosure. So in an aspect of the present disclosure, because once you say that in an aspect of the present invention, then the whole scope sort of narrows down to that invention. So tomorrow at a later stage, during scope assessment of your patent, a third party can say that this is what they said in their disclosure is their invention, right? In an aspect of the invention, so on and so forth. So they can always say that, okay, because you said that with respect to the invention, that is what your invention was. So to the extent possible, we avoid using the words invention, but we'll talk about all of this tomorrow as well. So I don't want to go through the pointers for specification, because that's the agenda for tomorrow. Set of method and CRM claims are to be included for US filings. For example, this is how a CRM claim or a non-transitory storage medium claim looks like. Modified features of the independent claim, modified form features. As I said, the main independent claim becomes your abstract, but you write it in a modified language so that you don't use words like said or plurality and stuff like that. This is again more boilerplate in that sense. I wanted to now go and spend about half an hour or so on some sample applications, high technology as well as some sample pharma applications. Now, I will look at some simple applications to start with, and maybe we can talk about the claims. Now, these applications were drafted by me, I think about a few months back, and they were drafted in a lot of hurry because the client wanted to get applications filed very, very quickly. And also, the budget and the time constraints were such that we really had to do it. So all of these applications that I will now show were drafted in about 1 day's time, maybe about 3-4 hours as a matter of fact. So this is a very simple invention. It talks about a fire extinguishing arrow and bow. Where any questions first of all before I get into these examples? Any question that anybody has?
So I have a question here with respect to the claims. So if plurality, for example, is objected to, could one or more be used in the claim?
Absolutely.
Okay, so there is no reduction?
These are very examiner specific, but one or more, at least one of any or a combination of all of them are usually acceptable to us.
Okay, so this don't reduce the scope or restrict the scope. For example, plurality and at least one of is can be used maybe synonymously.
Not really, because plurality will essentially be used
more than one.
Two or more devices.
Yes.
Any or a combination of one or more of are usually used as an expression when you are using it against a laundry list. Plurality will never be all. So you will say a plurality of hinges, a plurality of and because plurality is usually not a thing that will be used in pharmaceuticals that much, but in mechanical inventions, for example, a plurality of caps, a plurality of threads, which means two or more threads. One or more, at least one of is usually used in a laundry list. For example, you could say that your computing device can be selected from any or a combination of a laptop or a PC or a portable tablet or a mobile phone and stuff like that. Are you getting the difference?
Yes, any computing device, basically you're trying to give in the combinations. So I get it.
Yeah, so what I'm trying to say is that one or a combination of any or a combination of at least one of these expressions will be used when we are giving examples in front of them.
Correct. But like say, if you want to replace plurality in a claim, what would be the best way of replacing plurality if plurality is being objected to?
Two or more.
Two or more.
Or multiple.
Okay.
Yeah, but multiple becomes more ambiguous.
Broader.
Yeah.
And ambiguous also.
Or one or more. I mean, if the invention can work with one or more, then obviously the use of plurality was wrong. Because if you would have got an allowance with plurality, it would mean that you are mandating that the device has to use two.
At least two, yes.
Yeah. So then so that is what an assessment, because a lot of people, even when in our firm are getting trained, they're writing claims where they're saying that a device comprising of, caps, said caps being configured to, but then I ask them a very quick question. Can the device include one cap? And if they say yes, then it's absolutely incorrect to use the words caps or anything which is plural. So first assessment, you will have to make sure, can your invention function with one element, with one unit? And if the answer to that is yes, then please, for God's sakes, always use one unit. Never ever use multiple. Even if in 99.99% cases, it may use multiple, or it will use multiple. But if the invention can work with one unit, always you use one unit.
Okay. Okay. Thank you so much.
I have a question here.
Yeah.
So basically, if, for example, if a device has a sensor, for example, so if I just restrict it to a sensor, and so does it also cover more sensors?
Absolutely. Because again, Yasinta, you will have to go back to the same test. Tomorrow, if somebody makes a product with 5 sensors and you've written at least one sensor, is he using at least one sensor? Yes.
If I write just a sensor, not even like
sensor, yeah, he's using a sensor, right?
Okay.
A sensor means that of the 5, there is a sensor that he's using.
Okay.
So singular will always be covered under plural. And therefore, I'm requesting that whenever you're writing applications, if your invention can survive with one,
Yes.
always use one.
Okay.
Because a lot of people, for example, say that I receive feedback from 10 people and I process that feedback from each user, and then based on the processing, I give suggestions back to them. Then my question to them is that when you give a feedback back to a user that you've that you've received inputs from, are you considering the inputs that you have received from other 4 or 5 or 10 users? And if the answer is no, then the whole claim should have been with respect to one user.
Okay.
Receiving a first set of data packets from a first user, processing said first set of data packets using, say, whatever circulation convolution algorithm, so as to determine a second set of data packets which are correlated with some third set of data packets, and then given as feedback back to the first user. But the sooner we try and include multiple people in the ball game, then multiple people become compulsory. And you never want multiple people, unless without that, the invention will not work. Am I clear?
Yes, yes, sir.
Okay, so essentially what you mean to say is using multiple people or multiple users when the requirement is only of a single user is like using more limitations to your claim.
No, but yeah, more than that, what I'm saying is if you're using multiple people in your claim and tomorrow one guy does wrong and he copies and he says, I'm the only one doing it, and therefore your invention talks about multiple people would never include one.
That means the most simplest configuration is already out of your scope.
That's correct. The simplest configuration of one, which is what I said, when you're assessing the invention, you will have to first check whether it can work with one unit, whether it can work with one thread, one whatever bolt, one unit or not. If it can, please do not use multiple. Use one or more, there is no problem. You use at least one, there is no problem. But if you use receiving from bolts or receiving from, that you've already said it's plural, then you've stuck with plural. Then anybody using a singular will never be in the scope of your invention.
Okay, thank you.
So here, coming back to the example, this was a very simple, interesting invention. After a long time, I had written an application for this simple invention. And I'll come to the figures very strongly. So this was an arrow, and what he said is that when there's a fire in a house of a tall building, it's very difficult for somebody to reach there. People can't come down by the elevators, the stairs are sort of burning this house. So it's very difficult even for the firefighters to go up and sort of access that space. So this guy had a fire extinguishing arrow and a bow, and he said, there is some fire extinguishing material in here. There is a suction cup attached with it. So this is how it will essentially get attached. This portion, pink portion, will get attached to the wall, and this portion will disengage sooner it sort of attaches to a body, and all the fire extinguishing material is stored here. Are you getting? Then the shaft, that is. So he will basically, there's fire here. He said, I'll fire it here. Multiple arrows. And then, the fire will sort of, because the sooner it will go into the fire, it will get stuck onto that surface and release the fire extinguishing element, and the fire will all sort of flow down. That's what his invention was. But this is the claim that he had written. This is the inventor's claim. A device for extinguishing fire from long and safe distance. The device characterized in that comprising arrow, bow, fire extinguishing agent, liquid. So this agent, liquid, as I said, is in the shaft or the longitudinal hollow portion of the arrow. Now the question is this a good claim to write? Any thoughts by anybody?
First of all, comprising, before comprising, characterized in doesn't seem according to the...
But what is the biggest issue according to you?
Every element has been to, what do you say? There are more limitations here. Fire extinguishing agent, liquid or solid chemical. This and/or is ambiguous here.
There's slash.
Yes, because see, it can be any chemical.
But
Why would you?
do you see any other much larger issue?
So
Actually, the preamble also is very big here. A device for extinguishing fire from long and safe distance. So it can just be a device for fire extinguishment or whatever it is.
Any other issue? Something even bigger. See, the fundamental problem here, if you guys see, the fundamental problem is he's listed the elements, but he has never explained the relationship between the elements.
Yeah, that was the
You
correct.
will never get a patent for listing. If I just wanted to go with two examples together, here is another invention disclosure. So again, by separate inventor, but very simple. So this is a mosquito net that he has had. He says that mosquito nets are there and people still feel very hot inside in summers. People don't have ACs and there are many issues with the existing nets, and therefore he's made a new one. And he says that he will have some water passing through it. This is an inlet. There's some water pass through it and it'll sort of circulate the water in totality, and as over using the principles, some water will sort of evaporate out and will cool the environment, or the ambient temperature will come down of near this mosquito net. And this is how he's putting water into it, and there is a zipper and stuff like that. But if you again look at his claims, just wanted to go to his claims. Again, a device for evaporative cooling of mosquito net for controlling microclimate without using energy power. The device characterized in that comprising net inlet outlet change duct. So the higher point that I wanted to communicate first, never ever get biased by the disclosure of the clients or the inventors. Inventors do not know how to write patent applications, and therefore if we look at their claims and get influenced, that's the worst that we can do. The intent always should be understand the invention, just close this document and then write your own claims. Every element has to have interrelationship with each other. Obviously there is a problem and characterized in that and so on and so forth. But I would now want to go and just look at the claims that I had written down. This is very quickly done. So the title was Fire Extinguishing Arrow and Bow. The fire extinguishing arrow and bow was, so the field was very simple. Present disclosure relates to a fire extinguishing arrow and bow. When one is confronted with the fireplace, very clearly telling what happens in the current scenario, what are the issues and what are the solutions, and therefore there is a need in the art for better solutions which can essentially enable us to overcome the problems that are. And then there are multiple problems, and for the interest of the inventor, I had added all the advantages that are there of his fire extinguishing bow and arrow. So it is object of the invention to provide an arrow or bow for enhanced fire safety, provide bow that is easy to use, has no moving part, has no mechanical part, requires no power supply, so on and so forth. And I can share these applications if required. But coming to the claims, so it's very important that we have to write the relationship. A device for extinguishing fire from long and safe distance. Said device comprising a bow and an arrow having a hollow tube in which at least one fire extinguishing agent is filled in a manner such that upon touching with the fire, said tube releases at least one fire extinguishing agent to extinguish said fire. Now, can anybody suggest some problems here or some issues with the claim, or how we could have made it broader, for example? Because obviously we had to file it, and the question on this is how you practically end up drafting, but very happy to have somebody's thoughts on, is this, we could have done better here? How could we have done better in that sense?
I'm just suggesting in that way, it could have maybe, how about if there could have been some release mechanism? Maybe we can say extinguishing device having a release mechanism, and release maybe a device comprising a release mechanism, or maybe operating on something related to that, and then maybe bow and arrow could have been
sure. The only thing is that if you would have added that, you would have been mandated by the controller to then during the hearing show how that release mechanism actually functions. What is that release mechanism and the construction thereof? He may still ask us to do that as well. Even now, even in this particular claim also, he may ask us to explain how the tube is releasing the extinguishing agent. But the question is, sometimes because of paucity of time, sometimes the inventor doesn't have additional details. He is not giving you more data. And then if you ask, it sort of lengthens the whole period of time. But what I was trying, but it's a fair thought. I mean, because how is very important. Examiners are going to ask you for under 10.4 to explain the enablement of this. So he would definitely, he can even now ask us, how is it releasing and stuff like that.
The only reason I was asking is because the bow actually could be replaced by something like, a gun kind of device, which actually shoots the arrow rather than, someone mechanically using it. So how can that also be covered?
Yeah, that would not be. So this invention will always cover the arrow being a mandatory part. So for sure, if somebody is using a gun to dispatch it, that it will be probably a better and more efficient. But then if we would have written, then in that case, instead of an arrow or a gun, we should have written down a bow releasing mechanism or a bow releasing agent and stuff like that, and then probably explain it as examples that the agent could be a gun or an arrow, and that could have been a good claim, no doubts about it. An inventor probably would have been happy, sometimes not, depending on how he feels about the broadness. But yes, I mean, definitely, I mean, we could have written it like that.
Okay.
Any other comments? And anybody has, I didn't feel the need of writing a method claim here because it was a tangible product, and anybody copying it would usually have this combination, and therefore I never felt a need of another claim here in that sense. So we could have written an arrow claim. That is something that I now in retrospect feel that we could have written an arrow having a hollow tube in which and said arrow being configured as part of a device, said device also comprising a bow, something where we actually focus on arrows being, in which case, in point of Hyacintha's case, in which case if we would have claimed the arrow, then irrespective of how it is launched, we would have covered all our bases. We would have been agnostic. We would have been agnostic of how the arrow eventually gets released out through a bow or a gun or whatever.
I have a suggestion here. Hello.
Yeah, man.
Is it necessary to write here in such a manner that upon touching with the fire, because it is not always the case we are going to fire it with so much accuracy that it would touch the fire itself.
Very true. The only thing is that the lesser that you are writing, then in that case, obviously, the prior arts will become even higher. And I'm sure there are some mechanisms existing where people can throw something out. So, again, depends on the context of the inventor, what he's trying to achieve with the invention. Is he really wanting a broad patent or just a patent, or, it has various parameters. So you really have to keep the client in context while writing it. Otherwise, there is no end to it.
And one more thing is that last line, which is showing the effect of that extinguishing agent, which is not required, I think, because it could be. Is it necessary to write it also here?
No, it is not necessary, but if it is better explaining the invention without really narrowing down the scope of the invention, then if you would have only written an arrow having a hollow tube in which at least one fire extinguishing agent is filled in a manner, and then you would have not written in a manner such that is filled, then it's an empty claim. Then you're not really showing what happens. So what do I do then? Then the story is not complete. So sometimes it is important to explain the story. I'll just go through the mosquito net claims as well. Just 1 second. So again, microclimate controlled mosquito net. Very simple. This one para, second para. Therefore, there is a need. So 3 paras, very, very quick. This is all boilerplate objects. Just 2 advantages usually given by the inventor. They don't really make much. This is, if you look at this is just the claims being written down. and then all the figures, one line, brief description, summary being copy pasted here after the boilerplate. Yeah, this and this is the summary part, and then this is also the summary part, and then you talk about figure, explain the figures in that context, explaining of the figures. And this is how you then come to the claims. Evaporative cooled micro net comprising a water inlet that enables water to be received into a water duct that is configured in the net. A water outlet wherein the net is configured in a manner such that when the water is received in the duct, at least a part of the water rises due to capillary action, thereby wetting the dry net, such that due to subsequent evaporative cooling, temperature inside the net becomes cool, and wherein at least second part of the water. This was all not given by the client at all. First part, second part, how was it cooling? This is what we had sort of drafted it. But if you compare it with the claims of the inventor, he had just listed the elements. These chains were very immaterial. Mosquito net actually comprises all of this. So it is not right that the device comprises a mosquito net. It's the mosquito net only that comprises the water inlet. So what I'm only trying to tell you is that please do not get biased with the disclosure. Understand, develop a meaning, and then write the claims. Sooner you've written the claims, make the first claim as the abstract, copy the claim, make it the summary. Before the first detailed description, figure number 1, copy the summary and make the figures. And then you describe the figures based on how it is, and that's how you sort of claim it out in that context. Tapan, do you have 5 minutes? Can you explain the pharma draft, because you had run these BPCL applications? You might want to spend some time if you have 5 minutes.
Yeah, sure. So I think I had also already shared it with you. If you can,
Should I share anyone or any specific, the PDF one?
Anyone, I mean, anything will do.
You want to talk about this one, for example, crude unit overhead corrosion control?
Yeah, I think this has only the process claims, not the product claim.
But do you want to talk something about it?
Yeah, sure. We can go to the claims part.
Yeah, I'm there.
So basically, this particular invention lies in the fact that the particular corrosion inhibitors per se, all these because this particular application is already published, and I think the prosecution is going on in several countries in totality, and primarily this invention lies in the fact that the amine composition consists of 4 different amines. And as we can see, this specific the claim 1 is drafted in a sense that the preamble, as the preamble suggests, this is a method for inhibiting corrosion on internal metal surfaces of an overhead condenser of a crude distillation unit. Now, at a first sight, this seems to be more restricting. But just a point of one suggestion that I had, because we have been looking into several drafts and we have been discussing into what kind of claims should be drafted. The first and foremost thing, while while we are on a quest of reducing the number of elements that we put in the independent claim, we need to be very vigilant about the fact that the elements should not be so less that that it makes the whole claim indefinite. I mean, we can clearly write a method of inhibiting corrosion, but when we write such a narrow preamble, or if the independent claim does not have certain very specific and very much and the limitations that are very much required to give it a particular definite meaning, or to define its scope, then in that case it will attract a lot of different kind of prior art documents, and that will lead that will never lead a patent granted on such poorly drafted claims. So one has to have a certain specific meaning. So while drafting this particular application, we clearly had in our mind, because this is the composition that is specifically designed for crude distillation unit, and that is the reason that this particular amine composition works. This amine composition cannot work in all in preventing corrosion on all kind of metal surfaces, because this has been tried and tested by the inventors in specific crude distillation units, and that too only on the overhead condenser part, overhead condensers, this particular composition works. And now, as we can see, the method after the preamble, the method recites as the method comprising adding to the overhead condenser an amine composition in an amount and at a rate sufficient to maintain the pH of water condensate in the condenser above a pH of about 5. So the only necessary limitation over here is that the pH should be above 5. And so one can definitely tweak tweak the amount of or the rate of addition of this particular composition in the overhead condenser, and hence this claim has been written such that it is definite. At least we recite that it is a specific amount is added and at a specific rate. That probably we can define in the dependent claims. And followed by, we had drafted this to be a close-ended, the amine composition consisting of a mixture of 4 amines. The reason, because all these amines individually and along with few other amines were known in the art to be having corrosion inhibiting activity. So then, if in case we had if we had written this particular, if we had written claim number 1 by using the transitory phrase instead of consisting of, if we would have written comprising, then it would mean that certain other amines can also be present in this particular amine composition, and hence it would have become very obvious in view of the prior documents. So that is the reason that we had written it in a close-ended fashion, wherein it specifically recites that the amine composition consisting of a mixture of 4 amines, wherein the amines are ethanolamine, methoxypropylamine, morpholine, and cyclohexylamine present in a specific weight ratio. This specific weight ratio, as you can see, we had defined in claim number 2. In form of a range, that this weight ratio of monoethanolamine, methoxypropylamine, morpholine, and cyclohexylamine can range from this to this. And then further dependent claims were drafted, which gives definite which refer to specific embodiments of this particular invention. So as I can recollect, generally the invention disclosure form or the invention disclosure that one tend to receive from the client or probably from the inventors would be in form of a composition. So they may just share it that this is a composition that can effectively prevent corrosion in the crude distillation unit, and they had given a specific composition of these four amines in specific defined ratio. Then so we generally, in such a case, we always ask the inventor, or we typically inquire to the inventors if we can have a broader working ranges. For example, this particular working range that we have defined in claim number 2. Typically, and initially the client may not be aware of it, or the inventors may not be aware of it, and then in such cases, unless and until we clearly understand that, unless and until each of these 4 amines are specific, are used in a defined specific amount, the composition cannot work. I mean, once if we had not ensured that there can be a broad working or workable range, then in that case we may end up defining a formulation. So in that perspective, while drafting the pharma patents, because the majority of the patents are directed toward a composition or a formulation claim, typically we call it a composition when when the amount of each of the ingredient is not defined specifically, in terms of if a specific composition, if the claim may be a dry granulated or a granules or dry granulated product or dry granulated powder comprising ingredient A in the range of having an amount in the range of say 10 to 50 weight percent. So now all such claims are generally regarded as composition claims. Composition claims are always better in comparison to the formulation claims, because formulation claim defines the amount of each of the ingredient very specifically, and the formulation claims are very narrow in nature. So unless and until we have got few prior art document that may pose a problem while getting the patent granted, it is never recommended to draft the formulation claims. So while preparing or while drafting the composition claims, we need to be very clear about few of the things. One being the objection on section 3E. The controller or the examiner may always tend to raise an objection of section 3E when we draft a composition claim. So far as possible, we always need to be vigilant about the fact that in case objection on section 3E has been raised by the controller subsequently, what would be our answer? So whenever we get any disclosure of the invention, we always try to find out whether there is any specific improvement either in the stability or in the efficacy part, because whenever a formulation is prepared, the formulation scientist or the inventor or the concerned inventor has always got some specific goals in their mind, which generally the patent attorneys or the patent agents never receive as an input from the inventor. So first question we always raise to the formulation scientist or the inventor concerned is that what was the goal of preparing this particular formulation? What was the deficiency in the state of art? Because many a times we may end up getting an invention disclosure in the simple format that this is the formulation that we had prepared without having laid down what was the specific need, why this particular formulation was prepared. Either it may be due to stability or the shelf life, or it may be due to efficacy or the bioavailability part of it. And just to overcome section 3E, even if the formulation or the composition is exhibiting either improved stability or improved shelf life or even any other advantage from the formulation standpoint, then also we may simply claim that this is owing this superior activity or the desired activity is due to functional reciprocity of different ingredients. And it has been I had generally observed that it is a misconception in our mind that section 3E objection can only be overcome if we show the synergistic activity. That is not the case. If we read MPPP or the manual, it clearly says that section 3E objection can be traversed on two separate grounds. One, if we can show that the ingredients of a composition or a formulation exhibit synergistic activity there between. Another specific another specific ground on which we can traverse the objection of section 3E is the existence of functional synergy between two or more different ingredients. So in case we have improved shelf life, improved stability, improved efficacy, this itself provides enough empirical evidence suggesting that there is sufficient functional reciprocity between two or more ingredients of the composition, and based on this ground alone we can traverse the objection on section 3E. So while drafting such formulation or composition claims, first of all, if we had received a specific composition, we always should try and get the broad working ranges as far as possible. Once we have that broad working ranges at our hand, we should be we should draft the composition claims rather than a specific formulation claim. And and the example section and the detailed description in the detailed description and example section, we should specifically say, or at least recite that this particular composition has got advantageous stability or shelf life or efficacy, whatever data that we have at our hand. And just to be on a safer note, because we always need to keep ourselves prepared that in future looking at the composition claim, the controller may raise an objection on section 3E, and then so keeping that in mind, we should draft the detailed descriptions and specifically the example section of it.
Okay, thank you, Tapan. Any question that anybody has here? Tapan, do you want to go through other examples, or are they largely on the same lines?
I mean, each of these are largely on the same lines. Just one more point I just wanted to point it out. I think someone has raised a query or asked if we can write the product by process claims, or what would be the scope of product by process claims. First of all, I just want to bluntly suggest that never to draft product by process claim, because all over the globe, over all jurisdiction, the common settled position is in patent law is that whenever assessing the patentability aspect of product by process claims, all the novelty and inventive step must lie in the product itself. And so supposedly if we are looking at the claims, a wax composition, said composition comprising at least petroleum, at least this and this, and then if by mistake we had written this composition claim in form of a process, supposedly there is some novelty in the process and we had written a wax composition comprising this till end, till the last line. After that we may have written said wax composition prepared by prepared by any specific method. Then in that case, even if this even if there is any novelty or inventive step, I mean there are no method of preparing this wax composition. So there are few assumptions with regards to it. First of all, the product that we are reciting in the product by process claim, it should itself be novel and inventive. If any novelty or inventive step lies in the process part of product by process claim, it is always discarded or disregarded whenever it comes to assessment of patentability. And even European and even EPO and all other jurisdictions, they allow product by process claim only and only in such instances where the product cannot be specifically defined. I can specifically recollect that I had drafted one patent application where product by process claim, where drafting product by process claim was necessary. It was a case wherein the client had or the inventor had prepared a coal tar composition. Now that coal tar composition was prepared, as you all might have, those who are from a bit of a chemical or pharma background, they can very well understand that this coal tar per se is not a simple mixture of one or two ingredients, but it includes hundreds of different ingredients. And so basically the preparation of such coal tar would in general or typically be mixing of two or more different ingredients together to prepare such coal tar compositions. So when we heat these two or three ingredients, it may break up or prepare n number of different products that cannot be characterized. So basically a coal tar composition per se cannot have we cannot identify the exact ingredients that are present in any coal tar composition, and hence only in such cases where the composition we cannot define the product in terms of be it in form of composition having separate ingredients. In that case only the patent office, specifically EPO, will allow us to draft such product by process claims. So unless and until that is the case, we should never draft the product by process claims, because while assessing the patentability, the process limitations recited in a product by process claim will automatically get disregarded, and while construing the infringement, the process limitations will be construed to be present in the claim. So it means that for infringement of product by process claim, the product must be present, the infringing product must be the same, and that should have been made by the same process. So it is kind of a double-edged sword, wherein it hurts us from both the patentability perspective as well as from the infringement perspective. So with regards, this since we are looking into this wax composition, we can see that the claims, the independent claim is drafted in a sense that a composition comprises three specific portions. One being a petroleum based component extracted from any other combination of VLG, MVGO, HVGO, LVGO, and UCO. These are different kind of gasolines or oils that are typically present in the petroleum. So this is one of the component. Another component is ethylene-based polymeric component. Third is a Fischer-Tropsch wax or FT wax. And then we had characterized this wax composition and limited this wax composition by several properties, wherein the said wax composition exhibits any or a combination of a drop melting point ranging from this to this, needle penetration ranging from 10 to 35 when measured at 25 degrees centigrade, 5 seconds, 10 gram with 1 by 10 needle. So this is also an important aspect of it. So we have characterized this particular wax composition to be exhibiting at least one of these two properties recited as A and B. So unless and until the prior art discloses a wax composition that has got all these components, and if the wax composition exhibits any of these two properties, then only that objection of lack of novelty or the lack of inventive step can sustain. So many upon times it happens that we get such compositions which at a first sight does not look very good in terms of getting a patent granted. So in those cases, we should always try and see if the particular composition has got any physical or chemical properties that are exceptional. For example, in case of alloy compositions like this wax composition, so there are different kind of compositions that has got very specific physical and chemical properties attached to it. And very minute difference in the range of ingredient can have drastic change in the end properties or the desired properties. So we can draft the claims in a way that we first recite the composition part broadly without even defining what may be the percentage ranges of each of these components, and finally we can limit the claim by reciting the specific properties that we are targeting. For example, in case of an alloy composition and an alloy composition, said alloy composition comprising iron ranging from this to this, and different components, and followed by we can restrict the claim with one or more properties of the composition.
Thank you, Tafet. If anybody have any questions, very happy to take it. Otherwise, we can even speak about a little more tomorrow as well, and then before we move on to the specification components.
Just one question I had.
Yeah,
Hello.
Yes. Please go ahead.
Yeah. So, is it necessary to include an exemplary claim, like which is a very narrow version of the independent claim, as just as a practice to keep in case if tomorrow if we need to just take that particular claim in picture, so we have as a backup option.
As a second independent claim, you mean?
No, it's a dependent claim, but wherein we recite as an exemplary claim, like with all the elements, but with narrowed down ranges or maybe exact ranges, just one exemplary claim.
At the end of the day, yes, that dependent claims don't really matter too much. They only matter for the same reason that you were saying that if tomorrow the independent claim has an issue, we can include specific limitations on the dependent claims and move it up in the independent claim category. But apart from that, yes, I mean, you can, if the number of claims are within the range that your client would like, absolutely, by all means, you can, if your components has A, B, C, D, you can always say that A is in a range of 0 to 5% and B from the, or I mean, and that is how you will basically have a backup claim with narrowed down ranges, right?
Yes.
Absolutely. And I mean, before we move, and we'll obviously be happy to take questions today or tomorrow as well. Just wanted to maybe show slightly more complicated draft, but they're in the high technology space in that sense, more on the software side. So this is another application that I had drafted a few days back. It's been filed recently, and just at a very high level one. So again, as you would see, usually there's no system and method for written down here. This is for a US application, and hence you'll see the copyright notice here. And then again, the background section is usually just 2 paras. Therefore, there is a need of, and then there's no object here. So the summary is, as you would see, this is corresponding to the first independent claim. And so this client essentially says that you don't have to write all the claims in the summary section. So we've only limited it to the first independent claim. And this is again boilerplate. We refer to this tomorrow in this thing. But so this is how the claim was written down. This is so I always like claiming the device, because that's what is eventually going to get sold in the market. So anybody making a network device like a router or a switch or a gateway device or an intrusion prevention system, or any device which is tangible and provides security in a protected network, having one or more processors coupled to a memory having instructions, and the execution of the plurality of instructions enables the processors too. So earlier, obviously, we used to write more functional modules, where we used to write a receiving engine or a receiving module and a processing module. I think these days people don't writing like that. They write exactly like this, and then enables the one processor, and then you basically write, instead of the steps, you just write the steps like configure, enable, and so on and so forth. So this is how we had written down configure a super agent comprising of a plurality of this in a manner such that the agents are aware of other security agents and so on and so forth, and then enable. So these are the two steps that the processor essentially does. So there is a technical hardware element that does scientific or technical steps, and therefore the likelihood of this kind of claim overcoming section 3k is far higher than say a module claim, because modules are usually executed by a software per se, but here these two are steps which are being done by the processor, and hence the tangibility aspect becomes slightly better from that perspective. When you talk more about data packets, you talk more about bits and bytes, and there is a whole different checklist that we have for software patent drafting of how patents are to be drafted for software matters, where we don't use words like user does something, or there is a website or a web portal or stuff like that. We use everything is in the form of data packets and structured trees and information bytes and stuff like that, which is what makes the whole invention as much more technical as possible. And so we had a method claim. Method claim also becomes very easy with a system claim like above, like the network device claim like above, where you just, instead of writing configure, you write configuring, enable becomes enabling, and the rest everything largely remains the same. And then because it was a US application, we also had a non-transitory method claim where we talked about all of this. So final questions we can take, and then maybe park the others for tomorrow. Any other questions or comments? All right, then. I think no questions as of right now. Maybe you guys can think about it. We have 2 more sessions to go. So feel free to ask anything at all, or even email me out, or ask for anything that you need. It was a pleasure. Thank you very much. And look forward to see you at 11 o'clock tomorrow then. Thank you.
Thank you.
Thank you.
Thank you.
Bye-bye, sir.
Bye-bye.